Assalamualaikum everybody, and a very warm welcome to this webinar on behalf of VLA Virtual Legal Advisory. You've been seeing me for many months now, so you know who I am. I'm Sana Pirzada, and with me, I have got such an esteemed guest, a very inspirational personality, somebody who has accomplished a lot professionally, and somebody who happens to be a very down-to-earth human being. So with us, we have Hassan Ali Raza, who happens to be a senior associate at Dignam, and he's an advocate of the Supreme Court of Pakistan. Hassan, thank you so much for joining us today.
Thank you so much, Sana. It is such a pleasure to be over here, to be of some assistance, and thank you so much for the very kind introduction. I'm sure I didn't deserve all that, but certainly I'm very grateful to you.
No, Hassan, actually you deserve a lot more, but at this time of the day, all the words that I use for my Gothic fiction, I run short of them, obviously, because it's almost nighttime. But thank you for that. So, Hassan, as the audience knows, VLA runs a webinar series whereby we pick a particular topic, any kind of legal area, and we discuss it in order to make the audience aware of something that's pertinent. Now, for today, this particular topic on the benefits of mediation in commercial disputes, the reason why I actually selected this topic amongst others is because firstly, I know that you are an expert in this field, and who'd be better than explaining the entire process. And secondly, as we look at different sorts of agreements, commercial, contractual, partnership agreements, employment agreements, there are these clauses relating to mediation, to arbitration, and it's very important for people to actually understand them, because often what happens is that when you get a contract, you just review it and then you just sign it. Many organizations, even high-profile organizations, just go ahead and do it without actually understanding the intricacies of this process. So this is why I actually wanted to shed, I wanted you to shed some light on this. So if we could officially just kick off, Hassan, and I'll just ask you, very briefly, what, in your opinion, is the need for mediation or arbitration in commercial disputes? Please go ahead.
Thank you. Thank you for this question. Now, to understand mediation, we have to understand the entire process of dispute resolution. The regular process of dispute resolution is going to courts, filing a case, calling the other party to the dispute, and seeking to resolve it through the force of law. That is the regular process of dispute resolution. That process became very tiring, very expensive, very ineffective, very inefficient, which is why a layer was added to it, and it was called alternate dispute resolution. So it was an alternate to dispute resolution. Now, naturally, whenever there is a dispute between two parties, they look towards an authority to resolve it. In the court, the authority is a judge because he has the force of law. Hence, when we came to alternate dispute resolution, we had to mirror a dispute resolution mechanism, and we invented arbitration. We gave the authority to an arbitrator to resolve the dispute. But what was better in this? The intricacies of law, the technicalities of law, that was what was not present in arbitration initially, which is why it became a better source of dispute resolution mechanism. With time, what happened was arbitration adopted all the bad habits of litigation. It became expensive. It became extremely time-consuming. When we shifted from ad hoc arbitration to institutional arbitration, institutions made their own rules. We started circling around the technicalities of those rules. So it exactly became an added layer of dispute resolution. Now, when that happened, the first world sat together and they said, uh, dispute resolution has failed, alternate dispute resolution has failed. What do we do now? What is it that we invent by which everything goes away and the dispute is resolved in the most effective way? At that point in time, a term of art came into existence, which was called mediation. What is mediation? Mediation is where two parties sit informally together and create a formal outcome. So if both of us have a dispute, instead of involving a third party, both of us sit together and we create a settlement agreement, which is a formal agreement. This is as simple as it gets. It gives us greater degree of control. There is a preservation of relationship. It's confidential. Your and my information does not go to a third party. It's a quick fix mechanism. Now, you see, sometimes the issue is of communication. I am not able to communicate to you and you are not able to communicate to me, which is why a dispute happens. I cannot effectively put my point across and you cannot understand my point is what is a dispute. So when we sit together, we try and figure out what is it that I'm trying to say. What is it that you're trying to say? What is it that I'm understanding and what is it that you're understanding? When this happens, everything resolves. You see, if you want a can of Coke and I want a can of Pepsi, essentially we want the same thing, but we're stuck at brands. Maybe when we sit together, we say, oh, well, let's not have this, let's have something else. And this is a possible outcome. So we sat informally, but we created a formal solution. So so what is and when we come to mediation now, mediation, because it had so much room for improvement and so much efficacy, it is generally called the stepchild of dispute resolution. Professor Martin Lau in his book has said that mediation should not be treated as a stepchild of dispute resolution because the world of dispute resolution is scared about its efficacy. You will be surprised to hear that on 7th August 2019 is when the United Nations, through the Singapore Convention, first recognized mediation as a dispute resolution mechanism. 2019, this is as recent as it gets. In 2023, Pakistan has codified rules on mediation both in Sindh and in Islamabad. So we are right there. We are moving with the world. We are sort of recognizing it. The first world has just recognized it, and we are on our way. And the need for mediation, to respond to your question, is because now we need a quick fix mechanism to stay away from the clogged courts, to stay away from clogged arbitration proceedings. We need more party autonomy. We need parties to sit together and find dispute resolution settlements, as opposed to ruining money and time, years and years in the courts.
Thank you, Hassan. Actually, you explained that so eloquently and so wonderfully that it actually it helped me in understanding the entire concept a lot better. And I'm sure for the lay persons who have little or no knowledge about mediation, this is going to be extremely helpful. Hassan, in 2010, I briefly worked for a center in London, and they were a mediation center. Now, at that time, this concept was not understood at all in Pakistan. As you rightly said, and in fact, I was going to ask you that if you could just, narrate the chronology of mediation, which you've already done. So I'm not going to, ask you again. But at that time in England, they sort of equated mediation with things like if you had rental disputes, family disputes, and if you didn't want to waste your money by going to an expensive solicitor, just come to somebody who would act as a neutral arbiter and who could resolve, basically just somebody who could negotiate between both parties, as you've very beautifully explained. So this is something that previously, if I ever spoke of that in Pakistan, people didn't really understand what mediation was. There was litigation, and then on the other hand, there was arbitration. What we've actually seen, and you're absolutely right, is that arbitration, and I was reluctant to say it, but you've said it, does happen to be another, similar to the litigation process, in the sense that it has its own, I would say it has a lot of complexities. And it's difficult for the ordinary person who's signing a contract to actually understand it. Because if you look at most commercial agreements within Pakistan, they say, in terms of the arbitration clause, please refer to the Arbitration Act of 1940. Now, that is a huge act. And you have to look at so many different procedures. And if you're not a lawyer, and if you don't, even if you are a lawyer, but you don't have that experience per se in arbitration, you don't really know what exactly are you going to go about, unless we consult someone like you, and we know exactly what arbitration is. So hence mediation is something that has now become popular, or is now becoming popular, or at least known in Pakistan. So Hassan, again, just sort of continuing with this line of reasoning, when we look at commercial disputes in particular, and if we look at other things like family disputes, for example, or rental, or other areas as well, how in Pakistan, how does that, is mediation really used, and what are the different forums that people can go to?
Right. I think this is a very important question. If we understand correctly what mediation is, as I said, it is an informal process that leads to a formal settlement. Now, the problem that we face on a daily basis is that it's a more of a society problem. If there is a dispute between both of us, we will look to a third party to resolve it. If there is a dispute between two children, they'll look towards their dad. If there is a dispute between, let's say, a husband and a wife, they'll look towards a figurehead. If there is any issue between two parties, we are designed as such that we will look towards a third party. You don't need a forum for mediation. That is the beauty of this entire process. It can happen in a closed room between two parties without any third party. That is the best form of mediation. And why is that? Because the parties know what they want, and the parties know what they need. So want is unnecessary, need is necessary, right? So this fine difference of where will I settle is need. This urge to get more and more is the want. So you don't need a forum to resolve that. You just need to sit with the other party in a room and decide where you're going to settle with that party, what you're going to settle with that party. Now, having said that, why is it that there are accredited mediators? Why is it that there are individuals still present? The reason for that is that you need facilitators. The role of a mediator is of a facilitator. So I will facilitate what? I will listen to you. I will listen to the other party. I will cross-inform the two parties. I will negotiate with the two parties on. I will create that trust. And in the end, I will help you jog to a conclusion. That is the role of a mediator. I will not tell you that this is a good settlement or a bad settlement. Maybe it's a very bad settlement for you, but if you're happy with it at the end of the day, mediation is successful. So I will facilitate you in building that trust and in creating that decision for you. So number one, as I said, you don't need a forum. Number two, if at all you need a facilitator. Now that facilitator in a commercial dispute, for example, parties come to my office, we are doing it. Number two, there is this council, Musaleha Institute of Arbitration and Dispute Resolution. Mr. Justice Khilji Arif Hussain and the Legal Aid Society has formed it. It's accredited now in Sindh as well as in Islamabad. They're doing a fantastic job. They're providing all the facilities. And the third type of forum, and I think I have to commend my high courts over here, brilliant judges like Mr. Justice Hassan Aurangzeb, Mr. Justice Jawad Hassan of the Lahore High Court, Mr. Justice Babar Sattar, Mr. Justice Yusuf Ali Saeed in Sindh High Court. They have transformed regulators into mediators. If there is a company dispute, they've called the SECP and they've said, look, take off your regulated cap, put on a facilitating cap. Make these parties sit together. There are two shareholders, they're in dispute. SECP calls them to their office. It talks out with both of the parties. Both parties end up resolving it. It's an engineering dispute. Pakistan Engineering Council is called by these courts. They're told resolve this dispute. If there is a mining dispute, the judges call the mining department and they say, why don't you make these two working interest owners sit together and resolve the dispute? So these judges, why? Because they are judges of commercial acumen. They understand that the courts are clogged. They also understand that the subordinate judiciary does not understand the technicalities of commercial law. Biggest problem in our society, in our legal realm, is when I go to the court to argue a take-or-pay clause, the civil judge has no idea. He has no idea about limitation of liability. He has no idea about liquidated damages. These promissory estoppel. He's looking at me, and what is happening? Ultimately, he's delaying the case. He's like, I don't know why this lawyer is here. Let me just delay this case. It will go to another. So these judges have sort of created a room, and they have asked these NEPRA, OGRA, SECP, Engineering Council to wear facilitation caps and resolve disputes before with these parties. So what are the forums present right now? Number one, you don't need a forum. Number two, if at all you need a forum, you need a facilitator. It can be, it should be an accredited mediator. There are 40 of us who've been accredited in Islamabad. There are about 40 in Karachi. You can hire services depending on, rent dispute, family mediator, commercial mediator like myself, and there are others also over there. MICADR is a great forum. It facilitates that, and you can always tell the court, look, my dispute belongs to this regulator. Can you please tell them to facilitate it? So this is how it's working right now in terms of forum.
Brilliant, Hassan. Just two sub-questions that emerged from what you said. First of all, are there any particular rules and regulations that govern the mediation process and mediators? And secondly, when a mediator is appointed, I'm assuming that it has to be appointed by both the parties. So how does that work? If you could just briefly explain.
Right. So yes, so insofar as, let's break mediation into two parts. Mediation in terms of appointment of a mediator and in terms of the process that the mediator has to carry on remains unregulated to date. So choosing accreditation of mediators, that is regulated. Hence, some of us, we did our courses, we were accredited by the Islamabad High Court and then by the Ministry of Law. So that accreditation is done. Now, who will appoint it? That there is no legal regulation as insofar as that is concerned. It still remains unregulated, and I believe it will be regulated, but let's see when. The second part is when mediation has happened and an agreement has been signed by the parties. Post mediation, everything is regulated. The parties can take that settlement agreement, file an application in the court. In Sindh, the CPC has been amended. For this purpose, I believe there are several orders of the CPC, Order 10 specifically, if I remember correctly. And in Islamabad, we have the Alternate Dispute Resolution Act of 2017 and the Alternate Dispute Regulation Rules of 2023. So these two laws, they basically govern once mediation has happened and you file the agreement in the court will pass a judgment and decree in terms of that agreement, and then that agreement becomes a order which is executable by the court. So the first step, which is how will mediation happen, that's unregulated, but post mediation is regulated. Responding to your second question, as I just informed you, mediation is an informal process. So the appointment of a mediator is by the consent of the parties. It is generally called a pre-mediation agreement. That agreement is a tripartite agreement between the two disputing parties and the mediator that is appointed. He is told about his appointment, he's told about his fee, he's told about the venue, he's told about the scope of the dispute that he can try and resolve. There can be 100 disputes. You can tell the mediator, look, just one dispute is what we want you for, the rest we'll figure it out ourselves. So it is through a pre-mediation contract that the mediator is appointed and he starts performing his services.
Again, very helpful. Thanks for that, Hassan. Now, we've been speaking about the advantages and the merits of mediation, and we've been seeing how important it is now and how relevant it is over things like arbitration, litigation. But as with everything, you've got the pros and the cons. So could you just tell us a little bit about any downsides that might exist with mediation?
Right. Look, the story of mediation in Pakistan starts from the story of Turkey. Several years ago, a batch of judges went to Turkey and they were shown in Turkey that 3.3 million disputes were resolved through mediation. And effectively, the judicial system was clogged out. Now, 3.3 million cases is a fantastic figure for any judiciary to sort of hear, acclimatize, and then mesmerize about it that maybe Pakistan is going to become that country one day. So that is where Pakistan's judiciary got the idea about mediation. They came back straight away. They accredited mediators. They talked to different societies how to bring this in. They looked at the law as well. They tried to facilitate it and everything. But why is it that 2-3 years down the line, why isn't mediation in the real stream? Why isn't in the main light? Why is it that it has not been implemented 100%? The reason for that, as I said, is because mediation remains unregulated in Pakistan. That is the biggest problem. What the judges found out over there, but they could not implement over here, is something that was beyond their power, the legislative power. In Turkey, when mediation was introduced, or it was mandatory for all pending cases to be sent to mediation. And it was made mandatory that you cannot file a case before going to mediation. Right? That is missing in Pakistan. Hence, mediation has not come in mainstream. Hence, the downside, it is ineffective. For now, unless two parties are really sitting together, unless the two parties are determined to resolve, unless the two parties are at a level playing field, mediation will have no effect in your system because it is not compelled mediation, because it is not mandatory mediation. The law in Turkey makes it mandatory. The law in Pakistan does not make it mandatory. If a judge if a judge in open court presses parties, look, go to mediation, otherwise I'll not hear your case, he's actually not performing his constitutional duty of not doing his work. He'll be criticized, he'll be said, there'll be references filed against him. So a judge cannot be seen to be not working. He can only he can only advise the parties to go to mediation. Now, if you leave mediation to the realm of the parties, a dominant party will never be happy about it. And so if two parties are at so much notch that one party is so dominant, what can happen? The party that is in a problem will certainly run to court. It will certainly try to protect its rights. Or flip side, if a dominant party is in a great legal has a great legal mind and has obtained stay orders, interlocutory injunctions, why will he go to mediation? He's sitting tight and pretty for the next 10 years. I can manipulate the legal system, and the party which is at the other end will they're not going to sit together. So non-regulation of mediation, in my view, is the biggest downside in Pakistan that we are facing. There may be other downsides of mediation because it's informal, etc., etc. But I don't think we are at that advanced stage to discuss even, at that level of what disadvantages of mediation are. Non-regulation remains the biggest disadvantage in Pakistan market.
Thanks, Hassan. I personally feel that I asked you this question because there are two sides, of every picture. But the truth is, and we all know this, that litigation is a big problem in Pakistan by and large. Arbitration, as I've said, is a complex procedure. It's something that not everybody understands, and it has many intricacies. Mediation is something, in fact. As you rightly said, I really love the examples that you gave at the start, if it's a husband and wife or if they're two children, everybody, in whatever kind of dispute you're in, you do need a third person to listen to both parties and to enable both of you to come to some sort of a resolution. So I personally think that mediation, out of all of these different ADR modes, has more benefits. Just dealing with this a little more, Hassan, if you could, just enlighten us about some of the cases that you've dealt with. That we completely respect the confidentiality of the parties, and obviously, I'm not going to ask you to name anyone, but if you could just discuss the dispute, what was the problem, and how did mediation assist in that scenario?
Right, thank you. I think, I can discuss several disputes that I have been part of over the years. And before I venture off into that, it is extremely important to sort of appreciate that commercial mediation lacks gossip. It lacks emotion. It's dry, as opposed to family mediation, as opposed to mediation involving individuals where emotions are high. You have to build trusts, you have to build, as they say, you have to build repo. And so commercial mediation, on the other hand, is, I would say, it can be technical, but it is way more relaxed. It's more aim driven, it's more negotiating. It's how to bring the parties together to a commercial advantage. So keeping that in mind, look, one of my first involvements in a mediation matter was in the Lahore High Court Rawalpindi bench, where Mr. Justice Jawad Hassan, as I said, he has been doing great work, and he has been referring matters for facilitation mediation by regulators. So I've been involved in a shareholders dispute between two parties, and extremely old dispute, where one party is claiming 1% of shareholding and the other party is claiming another percentage of shareholding, and they're at each other's they're at each other's necks, and they've been arguing over fraud, they've been arguing over how the share register was changed, and they've been arguing that years and years. And judges, as you know, in Punjab, judges are on rotation. So a judge comes, he hears the case for 20 days, then he has to go to Bahawalpur, Lahore High Court, Bahawalpur bench, and then he has to go to Multan. So different judges, the matter remains pending, and then you're waiting for company judges to come. So Mr. Justice Jawad Hassan came, he looked at the dispute, he said, oh, this is an old dispute, but at the end of the day, I can see if both parties sit together, they can resolve this dispute. It's a question of just sitting together. And, we started looking at the parties and they're making those agony faces. And the judge is a judge. He noticed it, and he notifies the SECP to come in. And the SECP comes in, and the judge directs the SECP, please, can you call these two parties to your office on this and this day, make them sit together, talk to them, and let's see what happens on the next date of hearing. We went over there. The parties started, first off, they didn't want to see each other. Then they had to respond to the judge. So with that, they sat together. Now, when they sat together, it first started with an outburst. But then things started to settle. When things started to settle, one was claiming X%, the other was claiming Y%. And at the end of the day, when they started negotiating, it turned out to be X plus Y is equal to XY. And on the next date of hearing, we came to the court and we filed a settlement agreement. And that was the end of it. Likewise, there was a election dispute election of directors dispute. A party was claiming 3 directors, others were claiming 2 directors. The High Court called the SECP. We went to the SECP. They sat and they said, look, this is what it is. And do you want to resolve or you don't want to resolve? They resolved. Another very interesting concept. The parties came to the High Court in dispute. The judge said, look, this matter is a matter of company law. There is a concept in mediation called neutral party evaluation. So what happens is a neutral mediator gives a legal opinion regarding the merits of the case on law and facts. And on that basis, the parties get to know their legal rights and where they stand after 10 years of litigation. So His Lordship, Mr. Justice Jawad Hassan, asked for neutral party evaluation. The opinion came. He showed to both parties, this is what is going to happen after 10 years. They resolved the matter in 2 months. Likewise, now let's go to construction law. I was involved in a dispute regarding design of a construction project. The contractor had one agenda regarding design. The employer had another narration regarding design, and they were now on the verge of claiming serious damages because of that. Because if you see, in construction law, if a project has to be completed in 100 days, if the design is delayed because of any reason, the domino effect is that the 100 days is going to become 200, 300, 400. So if you don't nip it in the bud right in the beginning, the domino effect cannot be stopped. So as soon as that happened, they went to court, and in the court, the judge over there said, go to Pakistan Engineering Council. They will tell you which design is right and wrong. Pakistan Engineering Council facilitated the entire process. They told the contractor, look, your design is deviant over here, and the employer, you're demanding a bit too much extra. And they came to a conclusion to a design, and the dispute was resolved. Likewise, I can tell you in the exploration sector, now, as you know, Pakistan has pockets of gas reserves, pockets of oil reserves, and those can only be explored by working interest owners. Now, what happens is, if, for example, gas is explored, now that gas has to be evacuated within a certain point in time, because that gas will go in thin air, with your country in shortage. So now what happens is, generally when gas is explored, royalty disputes happen, disputes with respect to gas excavation happen. Parties go to civil judges, the civil judges grant stay order. Nobody is going to excavate gas without realizing that it is not possible. It's commercially not possible. Gas has to be excavated. So they went to, they came to the High Court. The High Court sent them to DG Oil, Oil and Gas. The DG Oil and Gas was made the mediator. He resolved the dispute within days. The biggest problem that I have faced in my experience in mediation is when there is a dispute with a state-owned entity. Now, with a state-owned entity, there is no ownership by the state. The individuals working in the state are only and only bothered about one thing. Will NAB catch me? Will I have to answer to the ministry? Will I have to answer to this office? Will I have to answer to that office? Now, in all that affair, settlement is frowned upon. They don't, so who will take the responsibility of settlement? If I settle today and tomorrow NAB says the settlement was against the interest of Pakistan and therefore public exchequer has been harmed, they will, that person will start being proceeded under NAB laws. That is where I've seen mediation really fail, because the state-owned entities are generally not interested, because they are answerable to somebody else. So these are some of the examples that I could think of.
These are just such brilliant examples, Hassan, especially the gas case that you explained so vividly. In fact, I was just trying to imagine it. I wanted to say that when we, so again, I'm sure that you have many other cases, and we would love to, sit with you at some point and have a much more lengthier webinar, or probably even a one-day program where we could, ask you to educate, participants. We could have something more official, and, where you could discuss the entire process that you followed in some of these cases. But just, for now, when we talk about the High Court actually asking the parties to go to, certain organizations for mediation, to what extent? Now, my concern is that in Pakistan, and I've seen the judiciary and the legal fraternity relatively closely. So whereas we do have many competent people, there are still many who unfortunately are not competent, and they themselves are not aware of the rules and regulations that in fact they are a part of. So I'm sure that many would not even be familiar with the concept of mediation. Now, you named Justice Jawad Hassan, and I have a lot of respect for him, because I looked at one of the judgments that he passed, which was to do with workplace harassment, and that's how I know, how knowledgeable and equitable he is. But in general, we don't have this awareness of mediation in Pakistan. People don't really, even arbitration is something that now people are beginning to understand, or gradually with time. So people generally, lay persons, don't know what that is. And even within the legal fraternity or within the judiciary, there are still many gaps in terms of knowledge and understanding. So you named some very competent judges who guided the parties towards mediation. But what happens in a case where the judge himself is not aware of mediation?
I think this is a very important question, because dispute resolution at the helm of affairs, it all boils down to the judiciary. Now, I can tell you that mediation is a concept that is very well known in our Supreme Court. Okay, and I can safely say that the judges that are present right now in Pakistan's Supreme Court are perhaps one of the most learned judges that this country has ever seen. The likes of Mr. Justice Qazi Faizi Saab, Mr. Justice Mansoor Ali Shah, Mr. Justice Munib Akhtar, Mr. Justice Ijazul Hasan, Mr. Justice Sardar Tariq Masood, all of them, one after the other, Mr. Justice Yahya Afridi, so one after the other, they are Roman gods of law, and they are very well equipped with the understanding of both civil law, commercial law, and criminal law. Now, this is something which is exponential. This is great. I mean, if you ask me criminal law questions, maybe I'll be scratching my head, but they're not. So they are very well versed with the idea. Let's come a step down. High courts. Now, I can tell you that the 7-8 judges that are present in the Islamabad High Court, excellent judges. Mr. Justice Amir Farooq, he's done a lot of civil law work. Mr. Justice Hassan Aurangzeb, one of the best arbitrators that this country has ever seen. Mr. Justice Mohsin Akhtar Kiani, again, another civil law expert. Mr. Justice Babar Sattar, Harvard. Mr. Justice Sardar Ejaz, Cambridge. Ms. Saman Rafat from Karachi, again, working great in these realms. Mr. Justice Arbab from Balochistan, done a lot of work. So these people, I am 100% sure. I mean, if I know them or I don't know them, I know that they know mediation. Lahore, I can tell you that out of 40 judges, at least 15 know mediation. Right? Coming to Sindh High Court, where the most commercial activity happens, right? And I met Mr. Justice Yusuf Ali Said at as an arbitration dispute resolution conference. What an eloquent judge! The way he speaks, the way he writes. I read his judgments, and I have to believe that Sindh High Court, where the most amount of commercial work happens, it will be beyond my understanding to not acclimatize myself that they know mediation. So there could be a few. There could be, criminal law judges, for example, they don't know about that. But if majority of High Court judges know, then it is my understanding that the remaining judges will also know. Now let's come to the problem, the civil judiciary. I cannot, with the same confidence, claim that the judges in the civil judiciary know about it. Now, my understanding is that the High Court judges need to step out of their courts. They need to start going to federal judicial academies, provincial judicial academies, call these judges, educate these judges that what is arbitration, what is mediation. They must make it mandatory for them to read books, to read international scripture, to educate themselves. Once you have become a judge, does not mean that you are know-it-all. That is the first step to reading more, writing more, understanding more. Like a doctor, a doctor can never claim that he's educated because the medicine that he prescribed 10 years ago is worthless right now. If you keep giving Disprene to somebody who has a headache, that person is going to die eventually. You see, you have to look at the contemporary. So education of these judges is extremely important, and that is where the superior judiciary is lacking. The head does not know what the toe is going through, the feet is going through, and the head must connect with the feet. And that is how, if the civil judges get to know, they will then teach the parties. You see, for example, in family disputes, I have seen where husband and wife fighting outside the court, going inside, and the judge telling them, go to the counselor room, sit over there, talk your stuff out, come back to me and tell me if you have had an agreement. Now that is mediation. It's a very raw form of mediation. It's a very bad form of mediation, but that is mediation. So you see, they have to, so the bulk of your cases is at the lower level, and that is what you need to educate.
I completely agree. And on that note, I'd also like to say that, even when we talk about organizations and when they're finalizing contracts with other parties, they seldom also know that this particular mode of dispute resolution exists. So what more do you think can be done to educate organizations about mediation?
Look, in commercial realm, the education will come from sector specific either regulators or organizations. If it's about accounts, the ICAP, Institute of Chartered Accountants, must do it. If it is construction, it should be through Pakistan Engineering Council. If it is architects, it should be through the Pakistan Architects and Town Planners Association. You see, so again, if it is the government must do it, the government must tell FBR, look, every time you want to go after a taxman, can you first make him sit down, talk him out, rather than freezing his accounts in this day and age where people barely have money. If somebody invests in your company $100 million, he's not coming over here that his accounts are being frozen. So make them sit down. If you think you have a claim of some tax, tell him that this is your claim. Figure it out. Maybe you can reach some settlement. So my understanding is the education has to, sector specific education has to come from sector specific organizations.
Noted. Thank you, Hassan. So as we're running out of time, just one last question, and perhaps it is something that you have spoken of, but just to make it very clear for the audience, when we talk about the different stages of mediation, if you could briefly just take the audience through the different stages from beginning till end, and also in terms of the enforceability of the award, just so that we clearly understand the whole process.
I think, as I said, and this we should not lose sight of. It is an informal process. So the stages are very informal, but they have been classified by organizations that are specializing in mediation. The first stage, as they say, is the stage of appointment of the mediator. As we talked right at the beginning of this webinar, that is the stage where principally the three parties, that is the two parties to the dispute and the arbitrators, sit together, and there is a pre-arbitration agreement with respect to the matter going to, a pre-mediation agreement with the matter going to mediation, the mediator being nominated, appointed, fee, venue, etc. So that's the first stage, the appointment of the mediator. The second stage is the opening stage. Now, what is the opening stage? Opening stage is where the mediator meets with both parties independently and then jointly. Independently to hear what their view is of the issue, and then jointly to see what their view is when they're in front of each other. Now, that way, he has a perspective. He has two perspectives, the perspective of each party and then the joint perspective of the parties, because I may be claiming 100 rupees from you and I may be talking a lot about you, but when I sit in front of you, I may not be claiming 100. I may be, I may lodge 200 rupees. Now, at that point in time, the mediator sitting over there exactly knows where you're coming from. Your mind is of 100 rupees, but when the joint perspective is that I want 200 rupees. So that is generally the opening stage where the mediator understands the individual and the joint perspective, and he builds a trust between the parties. Once the opening stage is closed, you jog yourself into the exploration stage. Exploration stage is, as I initially said, is the stage where the mediator has to figure out the need of the party as opposed to the want of the party. So want is your claim. Want is something that you can live without, but need is your absolute deadline. This is where you will settle. So a good mediator in that exploration stage will determine what is the need of both parties. Once the mediator has determined the need of the parties, then you start the negotiating stage. You break the parties, you go to one party, and you have to now bring that party from its want to its need, and likewise with the other party, and then you have to take that party that joint proposal together. So that is the negotiating stage, and it's one of the most important and the most aggressive stages. It's most time consuming because no party wants to budge from its situation. So once that happens, if the negotiating stage is successful, you go to the concluding stage, which is the agreement that is prepared between the parties, that all our disputes are resolved. This is my need, this is where I settle, this is their need, this is how I settle, and you sign off. So mediation has typically these 5 stages: appointment, opening, exploration, negotiation, and conclusion. So this full hand then leads to mediation. Once mediation happens, now I can give you 2 perspectives: international law perspective and Pakistan law perspective. International law, as I told you, that the Singapore Convention of 2019 has happened. The signatories to that convention, Pakistan is not right now. They are enforcing settlement agreements as judgments and decrees in their respective jurisdictions. So, like foreign R58, mediation settlement agreements are being recognized by signatories through their respective laws. Pakistan is not a signatory, so the only option for us is that the parties, once they have signed the mediation agreement, they can file an application in the courts in Pakistan and ask for a judgment and decree, so that if tomorrow a party to that settlement agreement backs out, you don't have to file a case. You only have to execute that mediation agreement.
Excellently explained, Hassan. And again, this was a very delightful webinar. Again, something that is just so relevant in this day and age, especially for organizations who are entering agreements. It's very important for them to know that you have another it's not just litigation and arbitration, but you have something else as well that many people don't know about. So Hassan, with that, I thank you sincerely for your time, for your expert knowledge, for the eloquent way that you've delivered everything. It's very articulate, very beautiful, for all the cases that you've shared, that you've worked on. Personally, I've learned a lot from you, and I'm sure that the audience would have as well. So all in all, thank you so much for your time.
Thank you so much, Sana. I could not have spent a better Sunday than today.
Thank you, Hassan. And for the audience, thank you so much for watching this brilliant webinar on behalf of VLA with the dynamic Hassan Ali Raza. And, we look forward to conducting more webinars in future, inshallah, with Hassan, probably on similar topics or different topics, as he has such diverse interests and expertise. And if you want to leave any questions, or if you want to leave any comments, or if you have any questions, please leave them in the box below this webinar. For more details about VLA, you can visit our website, vla.com.pk. If you want to connect with Hassan, or if you want to connect with me, we are both available on LinkedIn. With that, we thank you for joining us today, and thank you again, Hassan.
Thank you very much.